Good morning. The criminal trials are being conducted in two different forms. They, uh, During sessions trial, opening of the prosecution is provisions commencing in that chapter, wherein the public prosecutor must precisely intimate the court about the case and as well to declare that with which evidence is going to be, either is direct evidence or with circumstantial evidence. So that is that. But I want to share with you the fact that the circumstantial evidences are being adduced in not only in murder cases. There are so many other cases, 379 theft cases, robbery cases where the accused could not be identifiable. Then question of 498A and 306, 304B, rape cases wherein the accused after raping ran away or left the girl. So many things are there. There may be direct evidences also. So it is vital to understand what all are the provisions to be followed to defend to assist the court when the evidences are adduced under the second chapter of circumstantial evidence. See, the direct evidence, eyewitnesses are being examined, and single evidence is sufficient. It is subject to the approval and appreciation. Whether that evidence is believable or not, it is question to be decided by the court. But the circumstantial evidences are concerned, there should not be any gap between the chain link of evidence. It should be continuously linked with the circumstantial evidence. So now, in one fantastic judgment, the Supreme Court has given lot of ratios how to shake the circumstantial evidence. This is AR 2022, Supreme Court 5273, AR 2022, Supreme Court 5273, Ramanand alias Nandal Lal Bharti, State of Uttar Pradesh. Number one, they say till charges are proved beyond reasonable doubt on basis of clear, cogent and credible evidence, question of indicting accused cannot arise. That is number one. Then second thing they say, in case of circumstantial evidence, judgment would be essentially inferential from the established facts. So it should be in conclusive nature and consist only with the hypothesis of guilt of the accused. That is most important. Then this is most another important which may help you for 379 cases and other case 302 also. You can use before the Metropolitan Magistrate this ratio. They say when accused makes statement about leading to place where he has hidden weapon of offense, blood-stained clothes while in custody before two independent punch witnesses. The ratio of the Supreme Court says the Panchanama must contain exact words uttered by the accused. Otherwise, the 27 recovery is not believable. This is most important. And there are other things you can go through that is other not important. Because in this given case, one Panchanama was examined, not supported the prosecution, other Panchanama witness not examined. Then 27 I have already discussed about that. Then conduct of the accused. See, they say Section 8 of the Evidence Act says conduct of the accused may be relevant fact, but the Supreme Court says that should be considered along with other evidence on record. You cannot give conviction solely on the conduct of the accused. Then extrajudicial confession and judicial confessions were explained that you are aware of that. Section 24 of the Evidence Act. Then that is there. Then extrajudicial confession. It is very weak piece of evidence. Then the motive should be substantially proved when you attribute the motive. Because at the time of framing of charge, if they mentioned about the motive, then it is duty of the prosecution to prove that motive. Here in the given case, they have not proved it. Then you see, then false explanation of the accused. Where there is any infirmity or lacuna in prosecution, same cannot be cured by false defense. That is there. Then that is also most important. Then he says non-explanation of injuries over the accused. Though the accused was available, he was not taken to hospital. That was also raises suspicious investigation on the part of the investigating officer state. Then the other most important ratio here was that I want to discuss with you. That actually they say 304 pre-legal aid, CRPC. They say when Sessions Court capital sentences are being tried and the court should not appoint defense counsel naam ke vaste. You see, naam ke vaste means only for named purpose. They say in sessions trial, more particularly relating to serious offences involving severe sentences, appointment of experienced lawyer who had conducted such cases in past is advisable. Senior advocate practicing trial court should be requested to conduct case himself or himself on behalf of undefended accused. Therefore, that should be there. You know what action under section 24 CRPC. The appointment of district public prosecutor, city public prosecutor and state public prosecutors are being appointed from the panel and suggestion of the particular district judges and high court judges. But during the period of Purashik Talevar M.G. Ramachandran, that was relaxed. They say it is not compulsory or mandatory. That nowadays that causes much repercussion in conducting the cases. Here is also, unless and until you have a panel, you cannot command a senior counsel to conduct that cases unless he is sufficiently paid. That is the other things. But court can command them. But you have to prepare a panel of advocates. Let them prepare panel. Let the section 24 CRPC is restored back. I can't say more than that because that may affect the career of so many young advocates who had a golden opportunity to become public prosecutor and excelling their service. Some of them are excelling, but 50% are lacking some experience. Whatever it may be, it is up to the state to look after the law and order, and the defense councils will be very happy that the other side state government, state representing councils are weak in conducting trial. Okay, I understand this judgment would help you for circumstantial evidences are concerned, 27 recovery and Panchanama evidence of regarding these may help you in deciding the cases. The judgment running a multi-number of pages. It runs from page number 73 to at most It runs up to 53, 16, 53, 16, 16, 52 to 53, 16. So multi number of pages, but you have to go through the judgment, each and every prayer, and keep in your mind, at least you keep the index, the index of the judgments wherein ratios are guidelined. Best wishes.